Mrs. Rooney.
Lady, my lords, formally I will first of all thank the court for allowing us the opportunity of to have oral submissions and formally adopt the written submissions which have been lodged on behalf of the Ayr Centre. My lady, my lords, I was proposing, in a sense, to, clearly I'm not going to go through the written submissions, but just perhaps take up some points which have arisen in the course of this morning's submissions, if that would be of assistance. First point, and it in a sense echoes much of what Mr. Gill was saying, and I do say we align ourselves with the first intervener and with the appellant in the matter of specifically the jurisdictional issue. But first of all, the question of the proper approach to the interpretation of direct descendant in Article 2.2 of the directive. My learned friend, Mr. Keneally, says that, well, adoption is a matter which falls within the competence of the member states, and that therefore there should be a reference back to the member states on that point. I'd say that actually doesn't follow at all. Just because something falls within the competence of the member state does not mean to say that that means for the purposes of determining rights of entry, there has to be a reference back to the member state's approach when it comes to the facilitation of free movement. We know, for example, that marriage falls within the competence of each member state in terms of ages, in terms perhaps also of genders of the parties. But there it is. The fact is that in terms of facilitating free movement, a common approach has to be taken, and therefore those countries which do not recognise, for example, same-sex marriage, are required to recognise that family member means the spouse, which does, and it's not the spouse according to national law. There is a reference specifically to national law when it comes to the partner with whom a union citizen has contracted a registered partnership on the basis of legislation of the member state, if the legislation of the host member state treats registered partnerships as equivalent to marriage. That again is, but the interesting thing about that, there is a specific reference back to member state legislation and in the context of partner, but there is none when it comes to spouse. So just because adoption may well be said to fall within national competence, doesn't mean to say that therefore the matter is to be defined in terms of discrete national approaches to things. That would be contrary to the fundamental approach in EU law of autonomous interpretation. The court has frequently said, in one of its normal cut and paste approaches, it said this, and I'm sorry I don't have the case because I just had to call it up while hearing Mr. Keneally's submissions. For example, in the case called Commission Against Poland, C281/11, case paragraph 40, this is what's said, and this is a standard cut and paste approach. The need for a uniform application of community law and the principle of equality require that the terms of a provision of community law which makes no express reference to the law of the member state for the purpose of determining its meaning and scope must normally be given an independent and uniform interpretation throughout the community. That interpretation must take into account the context of the provision and the purpose of the relevant regulation. So a strong affirmation, the presumption is if there's no reference back to national law, because precisely as the court has pointed out, this impacts upon free movement, the presumption is that there will be an independent and uniform interpretation of the meaning of a particular term throughout the community. And in this case, it is what is meant by direct descendant.
In fact, we have Advocate General Bott says exactly that, and then goes on to apply it to the language of Article 3.2 in the Rahman case at paragraph 39.
Yes, absolutely so, my lord, and that's entirely consistent. But as I say, the presumption is, and it's not enough to say, well, adoption's within national competence. The presumption is, a uniform interpretation.
Mr. O'Neill, I was looking over the short adjournment of the upper tribunal decision,
Yes.
and they refer to a case called FK and MK. It's at 152 in the bundle. And do we have that, and does it help on a construction in accordance with what you say the principles are? 152?
It's a
Five
decision-
lines up?
Yes, and I see that.
Do we have it?
I'm not sure, my lord. I'll double check on that, but that's a decision of the is it the upper tribunal?
AIT as it was?
2007.
Well, don't worry, but
Yes.
it might be helpful just to...
I'll have
It might be good manners just to see what they had said about the meaning of descendants within these regulations.
Absolutely so, my lord. But of course, the point which I'm making is that because it's a matter, an interpretation of an EU law provision in terms of Article 2.2 of the Directive, direct descendant is...
Well, they may have factored that in, Mr. O'Neill.
They may have factored it in, but ultimately only authoritative interpreter of that would be the Court of Justice. For all the usual reasons about uniform approach across the EU as being central to the exercise, clear exercise of free movement. So it's not only that there is a need for a uniform application, but there's also a presumption against defining matters by reference to, if they're within EU legislation, by reference to national law concepts. Again, this is this was applied in a case a while ago called Man in Black. I don't know if the court remembers that. That was to do with it was to do with whether or not you could employ somebody as an agent in Luxembourg to buy all your cigarettes for you, the Man in Black company, and then send them all back on the basis that you were employing your agent. The agent acts as yourself. Agent is yourself acting, so therefore he was buying all those cigarettes in Luxembourg for you, and so you didn't have to pay excise duty in getting when you got your agent to send them back to you in the UK. That was the general approach in the Man in Black. There were adverts in the 90s, you had to be a smoker, not that I was, but in the mid-1990s, lots of adverts in the papers saying, get very cheap cigarettes by this cunning ruse, based on the notions of agency as conceived in national law. And the court said, sorry, nice try, but we do not follow they say this. It's clear from the case law of the court that the community legal order does not, in principle, aim to define concepts on the basis of one or more national legal systems unless there's express provision to that effect. So again, the presumption in favour of an autonomous interpretation is the approach, and the arguments against that by Mr. Keneally don't, when examined, stand up to much scrutiny. Second brief point, kafala is not adoption. That is plain. It is clear that kafala may represent an expression of a religious duty to bring up a child, an abandoned or kinless child, up in the Islamic faith. And indeed, we've seen that adoption, with its emphasis on the ending of kin ties, is, by some interpretations, un-Islamic, contrary to principles of Sharia law. So we are in an area of religiously... the kafala should be seen as an expression of religious faith at some levels. And that brings not just in issues of whether or not there is indirect discrimination, but arguably Article 9 ECHR reasonable adjustments issues. I'm just putting that out there. I'm not going to develop that further, but it's an important point in understanding kafala as being different from adoption for religious reasons. There is general clearly concern and interest in the issue of kafala as a form of long-term child fostering at an international level. I'm aware that before the UN Committee on the Rights of the Child, there's currently an application against Belgium, individual application 12/2017, which concerns the denial of a humanitarian visa to a Moroccan abandoned child taken under kafala by a Belgian Moroccan couple. As I understand the case, this is a child adopted, taken out of kafala in Morocco, but is being unable to be come back into Belgium, where the kafala parents reside, and the application in order to attempt to effect that family reunion, an application has been made for the humanitarian visa, international protection visa. That's currently before as an individual application, before the UN Committee on the Rights of the Child.
If it's Belgium, why isn't it in the Court of Justice?
Why is it not in the Court of Justice? Yes. There's a point indeed. I think, as I understand it, there are various ongoing matters. They haven't quite exhausted the Belgian national rights, but they've put this application in and it's not been declared inadmissible yet. Maybe it's just they attempted a double whammy. Lord. Those are those points. MK, Pakistan. I know your leadership has said that written submissions can be put in relation to this, but our general approach is that it's the Air Centre accepts that it has reached the correct decision on the basis of a straightforward, ordinary language analysis of a straightforward phrase of an EEA decision is one which concerns a person's entitlement. And it is perfectly clear that the application in this case concerns the person's entitlement to be admitted to the United Kingdom, and it requires, in fact, verbal gymnastics, previously unknown, to say, well, it doesn't really. And the odd thing is, of course, that it was the verbal gymnastics of the upper tribunal in Salah which first came up with a point which, at that point, the Secretary of State said was wrong, and that there was, in fact, a right of appeal. And it's only subsequently in MK that they suddenly reversed that position and said, actually, they got it wrong, the Secretary of State got it wrong in Salah, the upper tribunal, despite everyone saying they were wrong, got it right. Really, why? What is it that, why is it that they wish to change the position which has been in position for the past 10 years and say that there isn't and shouldn't be a right of appeal? It, at some levels, doesn't really make much sense because, on the other hand, the Secretary of State says, but it doesn't make any difference because you've got judicial review. Well, there are differences between judicial review and statutory appeals, and I'll point those out. But otherwise, the fact is that if MK is correctly decided, as I say it is, on the basis of at least the simple ordinary language analysis, that what we now seem to have is in the 2016 regulations an attempt to put Salah, which they said was wrongly decided, now into law. But if MK is correct and Salah was wrongly decided, then their attempt to put Salah into law by the redefinition of the EEA decision and the carving out of decisions such as ours has no justification.
Could we just have a reference to the 2016
Of course, my lord.
regulations?
The 2016 regulations are in the... Sorry, my computer's...
They're not directly relevant, so we needn't actually look at them, but it might be helpful for
Yes.
us in our own time to read them.
Of course, absolutely, my lord. The problem is I've created a far too long note of what I was...
Oh, don't worry, Mr. O'Neill. We'll find them.
I do have it, my lord, and I should have had that to hand.
Thank you.
But I will come back to the issue. But the point which I'm wishing to make at this stage, if MK is rightly decided, and I say it is, and that means there always has been a right of appeal in situations such as this, for the Secretary of State now simply to take away that right of appeal is done without justification, and therefore arguably is ultra vires on the basis, the same kind of approach which was adopted by this court in the Unison case, whereby the creation of hurdles, greater hurdles, in terms of possibility of access to the court, it contravenes the basic constitutional principle of right of access to the court, unless there's good and proper reasons for it. And at the moment, if MK is properly decided, there are no such reasons, and therefore it is without proper lawful authority.
SMS 141.
SMS 141?
SMS 141.
Right. Yes, the 2016 regulations, my Lord, are tab 7 of the consolidated bundle, MS page 1993.
Thank you.
And might as well just, since it's been raised, turn to that just to see what has happened. And what has happened is at page MS page 1995 or SMS page 143. Apologies for this, Malaria. I don't know why there's so many numbers. But EEA decision. We see it follows what was much as was said in 2006 regulations. It means concerns a person's entitlement to be admitted to the United Kingdom, but then it goes on, but does not include a decision to refuse to issue a document under Regulation 12.4 EEA family permit. And as I understand it, that has been done effectively to, that has been the statutory creation of the decision in Salah. So, of course, and I say, well, that's questionable both on domestic law grounds, because you cannot simply come in and interfere with existing rights of access to the court without good reason and proper statutory authority. And there is none here if MK is properly decided. But from a domestic, from an EU law point of view, we say the principle of effective remedy and effective judicial protection are in fact implicated in this matter, such that from an EU law perspective, that change is also unlawful. The written submissions have focused very much on the general principles of effectiveness and equivalence, and I certainly adopt those. But what I would say to this court, however, is that Article 47 is on the move, and that's why I put forward the case of Pushkar, because basically there is an interesting shift which is happening in the jurisprudence of the Court of Justice. The principles of equivalence and effectiveness were, of course, first of all, created really in Revit Central, I think, quite a while ago in the 1970s. Against a background of a presumption in favour of procedural autonomy, and that the general EU law principle was that there was no new remedies required as a matter of EU law. But what they did say was, you don't have to have new remedies, but what at least you have to have is equivalent. You've got to treat them in the same way as like claims in domestic law. And also there's a slight issue of, it's got to be effective, hasn't it? It can't be virtually impossible or excessively difficult. So those were the principles which grew up in the 1970s against that background of the presumption in favour of procedural autonomy and no new remedies principle. What has happened, however, is, of course, the treaty change which has come in with Article 19.1 of the Treaty on European Union. And that sets out the principle that member states are obliged to provide effective remedies in respect of breaches of EU law. So that was an innovation under the Treaty of Lisbon. Also under the Treaty of Lisbon, Article 4, subsection 3, the duty of sincere cooperation was reiterated. That, of course, long existed in the previous treaties under Article 10, Article 5. But it is, the jurisprudence of the Court of Justice has said very much that the duties of sincere cooperation under Article 4.3 of the Treaty on European Union applies directly to the courts of the member states. So the combination of Article 4.3 applying to the courts of the member states with the treaty duty under Article 91 to ensure effective remedies has now emboldened the Court of Justice to say that the no new remedies principle no longer applies because there is a treaty duty to ensure remedies. And we know that the remedies which the national courts are required under Article 4.3 to provide have to be effective remedies for the purposes of Article 47 of the Charter. So it's the combination of those three provisions which has then led the court, really this year, to move away from the older paradigm of equivalence and effectiveness to focusing on, is there are the standards of effective judicial protection actually being embodied and protected by and before the national courts when it comes to EU law. That has only happened really since the case of Berlioz, the Grand Chamber decision in May, but the case of Pushkar, which I've just sent up, confirms that that is the change in approach, and that's why I gave it to the court to read over lunchtime, were they so minded. But and as I say, the importance, it is an important shift, and the court should be aware of it, and it's a shift which has happened since the written submissions were put in this case, so nothing like being hot off the press.
I think we did refer to it in unison.
I was going to come back on unison, absolutely so, Lord, and indeed there are, I wasn't going to, unison has a lot of interesting and useful passages, I would say that, but it does, absolutely so, my Lord, but even in unison there's a reference still to equivalence and effectiveness, and also, as separately, to the principle of effective judicial remedy. But I say now, really, in accordance with what Advocate General Cocotte has said, which of course that was a decision which I think was put up to the court, the opinion was put up to the court in unison, but of course the decision of the court postdates the unison decision, is that effectively, as she says at Article 51, Article 47.1 of the Charter and the principle of effectiveness effectively embody the same legal principle and must be examined jointly using the rules in Article 47 and Article 52, which is not just proportionality, but respecting the essence of the right and being in accordance with law. So that's the approach which one takes, therefore, rather than constantly seeking for an equivalent or asking whether this is excessively difficult or virtually impossible. You say, is the remedy which is being proposed here, judicial review in this case, as opposed to the pre-existing statutory appeal, does it conform to those requirements of Article 47? It's a substantive basic level of protection. And what we note in Pushkar against Slovakia, the decision which I handed up, is the dispute there was whether it was lawful, compatible with Article 47, to have a requirement under national law for a prior exhaustion of administrative remedies before coming to the courts. Now you think, well, that's, that seems reasonable enough, but on the facts of the case, the court found that that requirement of prior exhaustion of administrative remedies introduced, as they say at paragraph 61, an additional step for access to the courts. And they agreed with Advocate General Cocotte that such a procedural rule would delay access, not prevent, delay access to a judicial remedy, and could also cause additional costs to be incurred. So, we can see how that maps on directly to the change which is being pushed in this case in terms of the lack of statutory appeal or the taking away of a statutory appeal. The fact is that the taking away of statutory appeal does hinder access to the courts, that judicial review is not as easy a way to get into the court. We can say this on the following grounds. First of all, there is a right to a statutory appeal. Whereas there's no right to judicial review, you have to get over the permission stage. Secondly, the work in preparation for any such appeal in a statutory appeal will be covered by legal aid or exceptional funding if it's an EU law point under Section 10 of LASPO. Whereas we know that no legal aid is available for all the preparatory work, which is done in the very front-loaded requirements of judicial review and it's done at risk, whether or not you've got an EU law point or not. The hurdle of seeking permission can be quite a difficult one to overcome, although at some levels one talks of the hurdle as being an arguable case. The number of hurdles that one has to go through sometimes to convince somebody it's arguable can be considerable. You can be going through 3 or 4 hoops. You can be refused on the permission, on the papers. You then have an oral hearing before a single judge or perhaps a divisional court. You can be refused there, and you can then appeal, of course, to the Court of Appeal, which may then consider it on the papers or may then put it out to a hearing. And that's still at the permission stage before you've even got anywhere in terms of the substance of the hearing. And you've got to have found lawyers who are willing to do all the work at risk, because they're not going to get legal aid, assuming that you would otherwise be covered. That's totally different from a statutory appeal, which is presumably why, in fact, the Secretary of State thinks, well, if actually I take away the statutory appeal, that will, in fact, reduce access to courts. But he's not saying that. And he's saying instead, judicial review is so flexible, you don't have to worry about it. We're not really making any difference. This is simply a cosmetic change. It's not a cosmetic change. It makes a difference. And I say, because that appeal right existed before, the taking away has been without any justification in national law, and the taking it away causes the imposition of an additional hurdle, which is contrary to those substantive requirements of Article 47. So, and unison is very, very useful on all that, but pushcard goes a wee bit further. So, with all that then, my lady, my lords, I think I've got my half hour.
You just about have, but could we ask you one question?
Of course,
because you or those sitting behind you are possibly the most likely in the room to know the answer to it. And that is, do we know what sorts of remedy other member states give to people who have been denied a residence card or an entry, denied entry to another member state?
Well, I mean, that's very interesting, and I don't immediately know the answer because, of course, under the Schengen approach, there's far more of a uniform approach to, for example, the approach to humanitarian or application for visas and the like. But interestingly, there is a directive of 2013 which says which applies to Schengen area countries, which is to do with refusals for a humanitarian visa, which says that there has to be access to a tribunal which allows for an ex nunc looking at the facts of the matter. And they say that that is a minimum requirement. The provision in question, because I better give the court that, is, but we can certainly do more work on that.
Well, we don't want to put you to
particular point, but
too much work, but we just thought you might know the answer.
Well, it's the sort of thing I should
I think
know
I
the
asked
answer
the right
to.
question, did I not?
Yes.
Yes, the directive I was referring to is Directive 2013 of 32, which establishes common procedures for granting and withdrawing international protection pursuant to Directive 2011-95, and it's Article 46 of that directive, which sets out the appeals procedures against administrative refusal.
So it's a merits appeal, at least within Schengen.
For a full and ex nunc examination. This is what it says. This, in order to comply with this, member states shall ensure that an effective remedy provides for a full and ex nunc examination of both facts and points of law.
Sure.
Yeah.
It's as clear as you can get in terms of that general approach to what an effective remedy, and that's said to be in conformity with and required by Article 47.
And you have a minute just to turn round and pick up the post-it, which Miss Mole is seeking to present to you.
One, I have got FK and MK on my laptop. So it's the short analysis of the wording of the directive to answer my Lord Wilson's point, but we'll deal with that. It was only when a DNA test came out that sponsor found the children were not his. There was no intention to adopt. I think this is on the facts of Matt Sewell. Okay.
But it looks
Well,
as if it,
we can find it.
And I'm sure all the other EU states also have the family reunion directive, I'm
Yeah.
told. So, but we can, if there's any other points in which we can assist the court, we're more than happy to do so, Lady.
Thank you very much indeed, Mr O'Neill. Thank you.
Obliged.
I adopt both my learned friend's submissions, but may I just quickly deal with the last point that Mr. O'Neill made as to why judicial review is inappropriate. Firstly, I'd ask you to pick up the Commission's view, which is MS 724. There are passages in the communication which strongly suggest that a refusal under Article 3.2 does attract a right of appeal. The first reference is at page 724, just above paragraph 2.1.2, last sentence.
Open to appeal.
The second reference is at, with reference to other family members, is MS 726, the last sentence above paragraph 2.2. And the third reference is at MS 734, paragraph number 3.6, particularly the second paragraphs, which refers to the factual and legal grounds on which the decision is taken. And then there's a reference to Article 47 of the EU Charter, which my learned friend, Mr. O'Neill, has already made submissions. The second case which supports the propositions advanced by my learned friends and which we had already addressed you, that judicial review is ineffective, is set out in our written case in the supplementary bundle SMS 14, with particular reference to paragraph 32, and there's a reference to the case of Brahim, which is found in the authorities bundle.
I'm sorry, what was the page reference? I don't think,
42.
SMS 14,
I don't think it's 14.
No,
paragraph SMS page number 14. This is in the supplementary bundle.
it can't be.
Can't be.
Can I come back then to that particular reference? This was the written submission made by us in relation to jurisdiction at paragraph 32. May I come back to that? It's,
Tab 9.
Did you say paragraph 32?
yeah. It looks like something has gone wrong, but can I refer you specifically to the case of Brahim, which is in our bundle of authorities, and I'll come back to that in a moment, if I may.
Paragraph 32 is at page 14. I think you were right. It is at page 14 if you get the right SMS.
Yes, it's the first supplementary bundle.
Yes,
It's the first.
I was looking at the final bundle which had everything
I'm
in
ever so sorry. It's on the first supplementary, in the first supplementary bundle, SMS page number 14,
Is that the yellow one?
the yellow one.
Yeah.
Yes.
And there's a reference to the case of Brahim. And may I, with your indulgence, come back to you and tell you where it is in the bundle of authorities. And then finally, two more domestic cases, which in this context indicates that judicial review is not as effective as a statutory appeal. is the case in the High Court dealing with an Turkish national with the rights of appeal, case called At-Turk, and the reference is SSMS, commencing at 1105, but it's particularly at paragraphs 83 at page SSMS 1117, and finally, the case of MK in the Court of Appeal and the views of Lord Justice Irwin at paragraphs 46. May I come now to the primary submissions that I want to make, which are very short. Firstly, I will be open to criticism for having given you some photographs of Sarah, so we have a visible person to an abstract name. I presented them to you, and I invite you to make of it what you wish, so that we are speaking of a person, a child. The point that I have to address you is, what is the meaning of direct descendant in the directive? Is it simply confined, in our case, to a biological child or to a child adopted according to the Hague Convention? Lady Hale had asked the question, do the immigration rules apply to this type of case? And may I ask you to pick up in the core volume our submissions made to the FTT at MS 226. At paragraph 5 and 6, we cited the relevant immigration rule, which precludes the appellant then relying on the immigration rules, because her case or claim was brought under the EA regulations. That's true. And we set out at paragraphs 5 and 6 the relevant immigration rule. And the same.
It only applies, doesn't it, when when the person concerned is entitled under the EU regs. If you're not, you can fall back on the immigration rules.
That is right.
Yeah, okay.
But subject, of course, to the question of entitlement, which is a separate matter, which I have to address you very briefly with reference to jurisdiction. And we made the same submission before the upper tribunal for your reference number MS 248 at paragraph 12. We respectfully submit that the way that the Court of Justice would approach this matter, that is, how to respond to kafala, would be by reference to Article 21 of the TEU at SMS 36. And can I ask you to pick it up, because I have 3 points to make with reference to Article 21. This is
SMS, the first supplementary.
Yes, the yellow bundle. Yeah.
Thank you. So, sorry, your page reference was?
SMS 36. And it's Title 5, General Provisions on the Union's External Action, Specific Provisions, Common Foreign and Security Policy. It's Article 21.1. The Union's action on the international scene shall be guided by the principles which have inspired its own creation, development, and enlargement, which it seeks to advance in the wider world, democracy, the rule of law, the universality and indivisibility of human rights, fundamental freedoms, respect for human dignity, the principles of equality, solidarity, and the respect for the principles of the United Nations Charter and international law. And we have 3 points to make. First, it would have regard to the principles of equality. And as you know, this is a case where we have said all along, the agreement was the father would bring up this child in accordance with the Muslim faith. And one of the aspects of the Algerian code was that it would not recognize adoption. Second, the international law instruments would be treated on par. And in other words, it is our respectful submission that the International Convention on Adoption, the Hague Convention, would not necessarily be given precedence over the UNCR, namely Article 20, which we have made reference to. And can I simply refer you, in our written case, we have dealt specifically with Article 21 of the UNCR for your note purposes. It's MS 83 at paragraph 48, to paraphrase, that adoption is not the only solution to a problem that you are now confronted with. This paragraph 48, MS 83, and the last sentence of paragraph 48 encapsulates what we say in that paragraph, that Article 21 makes it clear that the provisions on adoptions do not apply to these Islamic countries. That entire paragraph, we say, is relevant. And the third submission we make with reference to Article 21 of the TU is that the EU treaty is the supernorm which will decide and guide the court on the issue as to the meaning of direct descendant under the directive. And lastly, with reference to Article 2.2, may I just respond briefly to the facts to remind you, because we have made our submissions in some detail previously, but to remind you that with reference, or rather in response to the respondents' written submissions, their later submissions, that there is no clear evidence that the child has been abandoned. I ask you to note in the SFI at MS 59, paragraph 6, that it appears to have been agreed between the agreement between the parties that Sarah was abandoned, and the birth parents had 3 months to reclaim the child. There is a report at MS 315 which confirms that Sarah was taken in by the orphanage when she was 3 months old, and the birth mother has not left any information. And the wife's witness statement confirms this at paragraph 16, MS 334. If I give you the reference as to why we say there has been a rigorous assessment over a period of 18 months, it would invite you to relook at the following documents First, the SFI, paragraph 5, MS 59, and then the witness statements of the wife, paragraph 6, 9, 11, and 13, commencing at MS 325. The legal custody deed is at MS 362. The guardianship document is at MS 359. And the clinical psychologist's report dated 9th of January 2014 is at MS 315. I had drawn your attention to at the previous hearing that this is not a case where there is a risk of abuse, because the grounds of appeal advanced by the respondents to the upper tribunal prayed in aid abuse. That is MS 264, paragraph 8. But that ground was rejected by the senior judge, Allen, at MS 265. And the tribunal, upper tribunal, found that the current exclusion of Sarah impacts on the sponsor's EU rights, SSB 10, page 10, at paragraph 20. May I move on to the jurisdiction issue, the Sala point? I first would like to I've drawn your attention to the Commission's view as to why there should be a right of appeal, and I do not think it's being suggested by the respondents that judicial review is a more effective legal remedy which is available. If I could invite you to take note of the following, that in Rahman, the Court of Justice uses the term family member interchangeably in the same way as, or at least suggesting, in the same way as it has been used in the Citizenship Directive. And the paragraph numbers at tab 42, MS 1614 onwards, paragraph 21, 26, 33, 35, and 46.2. We respectfully submit that the MK decision or the judgment is correct. But if I ask you to pick up MK at SSMS 1055, tab 37.
1055.
Yeah.
Supplementary authorities too.
Volume 2. Tab 37. And could I ask you to look at paragraphs, this is commencing with the judgment of Lord Justice Longmore, at paragraphs 49. And he cites Lord Halsbury's judgment in Sharp with reference to discretion, and it means when it is said that something is to be done within the discretion of authorities, that something is to be done according to the rules of reason, justice, not according to private opinion, according to law and not humour. If that something is a decision which is not according to law, claimant has an entitlement to relief. Or at the very least, that decision is a decision that concerns an entitlement to the object sought to be obtained, here a residence card. And with that in mind, may I ask you to pick up the 2006 regulations, which is at SMS, and that's the yellow bundle, at page 116, Regulation 8 defines who is an extended family member, and it's subparagraph 2, which sets out the criteria which the applicant has to meet. In this case, we, with reference to Article 3.2, had submitted that Sarah had met all the conditions, and that's how the upper tribunal viewed it, that she was a relative. Regulation 2 defines a family permit, SMS page 112, midway, as an EA family permit means a document issued to a person in accordance with Regulation 12 in connection with his admission to the United Kingdom. And so that may be a family permit issued to a family member or extended family member. And Regulation 12, SMS page 119, sets out in paragraph 1 the conditions which a family member has to meet. In paragraph 2, it sets out the conditions which an extended family member has to meet. A, the sponsoring EA national must satisfy the conditions in paragraph 1A above, that's residence in the United Kingdom in accordance with the regulations. 2, the extended family member wishes to accompany the relevant EA national to the United Kingdom or to join him there. And if you recall, an extended family member is defined in Regulation 8. And C, in all the circumstances, it appears to the entry clearance officer appropriate to issue the EA family permit. And our submission, taking into account what Lord Justice Longmore said, is that that discretion is not open-ended. It is circumscribed, first, by Regulation 8, and second, that is self-evident by subparagraph 5 of Regulation 12. An EA family permit shall not be issued under this regulation if the applicant or the EA national concerned falls to be excluded from the United Kingdom on grounds of public policy, public security, public health, in accordance with Regulation 21. And if you turn to SMS page 123, Regulation 21 says that a relevant decision means an EA decision taken on grounds of public policy, public security, or public health. And the point I wish to make with reference to Regulation 12.5, first, it addresses the point that Lord Hughes had raised with Mr. Gill, that Article 27.2 seems to throw the spotlight on the person concerned, but we respectfully submit that Regulation 12, subparagraph 5, puts the spotlight not only on the child, but on the sponsoring EA national. That must be so. And second, if my learned friend's construction on EA decision is correct, then a decision taken to refuse a child or a parent under Regulation 12.2 on the grounds that it is a fake relationship based on public policy would attract a right of appeal under Regulation 12.5 because it's an EA decision under Regulation 21.1, otherwise 21.1 would be redundant, but then that puts a person who is a bad apple in a better position than a person like Sarah. where there is no suggestion of any abuse, but who is not granted a right of appeal on the basis of my learned friend's construction.
Mr. De Mello, could I take you back to Regulation 8.2 on 116? Because I'm having some trouble understanding the requirements for the admission of an extended family member. And I'm having some trouble satisfying myself that the transposition here is in accordance with the directive. Could we look at 8.2? A person satisfies the condition in this paragraph. If the person is a relative, well, there's a problem about that. Let's skip it. Person is a relative of an EEA national. And A, the person is residing in an EEA state in which the EEA national also resides. Well, that doesn't apply to your client. B, the person satisfied the condition in A and ... wishes to join him there. And so I suppose the reference to satisfied is a reference to what happened in the past, and so one then has to go back to A and read it, correct me if I'm wrong, as being the person was residing in an EEA state in which the EEA national also resided, and is a member of his household. Now, if that's anything like right, if the requirement there is to have resided in an EEA state, where is that to be found in the directive?
Certainly. I think Rahman provides an answer to that, that the requirement of residence in EEA state is not entirely correct with reference to the directive.
I think you are right.
And
although Regulation 8 was quoted in that case, it wasn't, of course, being directly considered because they were considering the EU position.
yes,
But I think the clear inference is that there is no requirement in the directive for past residence together in an EEA state.
that I think was not an issue between the parties, because I think the judgment in Rahman at some stage had confirmed that to be the case, that residence outside the EEA state.
Well, has there been any reported case on the correctness of the transposition in our 2006 regulations of the directive?
Well, standing on my feet, the answer to that is yes, but I think would probably, if we just pick up Rahman at volume 4, tab 42,
Have your page.
it commences at MS 1585.
I wondered whether you might be referring us to paragraph 34 of the judgment
Yeah.
on 1616. We are focusing, of course, on the directive.
Yes.
The court says it's for the National Tribunal to establish whether the applicants were dependents of the Union citizen, in this instance, Mrs. Rahman, because she was the Irish EU citizen,
Yeah.
in the country from which they've come, Bangladesh.
Yes. And I think the preceding paragraph then also clarifies the position.
Yes. Nothing about residence in an EU state.
Yes, and my lord, we haven't troubled you with that point because that has not been in dispute.
I see.
Simply because
I hadn't realized that.
mother and child, the sole issue before the upper tribunal, because she failed under Article 8, was that she would succeed either under Article 2.2 or 3.2, but the upper tribunal decided to look at Article 3.2 by reference to Article 8 and considered that she was a relative and satisfied the other conditions, notwithstanding the expression of subparagraph 2, subparagraph A. So my lord is correct to the extent that Regulation 8.2, as worded in the 2006 regulations, did not transpose the Citizenship Directive correctly.
Thank you.
I don't want to prolong it very much, Mr. De Mello, but there are alternative conditions in Regulation 8, aren't
Yes,
there?
there
Including
is.
particularly number 4, which hasn't got a residence requirement and indeed doesn't have a residence requirement in relation to the sponsor either.
Yes.
Yeah. Okay.
But for our purposes, the case focused on subparagraph 2.
Yes, I follow that.
So our submission is that the Court of Appeal was correct in its conclusion and that the discretion that is contained in Regulation 12.3 is not open-ended, it's circumscribed. May I say two other things, or rather one other thing, that my learned friend's construction would, if correct, lead to a further absurdity, because if you look at the 2006 regulations at SMS 131, it commences at page 130. This is paragraph 4 of Schedule 2. And if you look at subparagraph 8 on page 131, section 120 of the 2002 Act shall apply to a person if an EA decision has been taken or may be taken in respect of him, and accordingly the Secretary of State or an immigration officer may by notice require statement from that person under subsection 2 of that section, and that notice shall have effect for the purpose of section 96, subsection 2. And put bluntly, what it is you will be given an opportunity to advance a human rights claim, if you so wish, as an additional part to the refusal. If my learned friend's submission is correct, that there is no EA decision in respect of a decision taken under Regulation 12 or Regulation 17.4, then the benefit of Section 120, that's the one-stop notice of appeal where you put all your human rights claim forward, would not be available to such a person, which is an indication that his submission is wrong on the construction of Regulation 2. That really completes the submissions I wish to make. We have, in our written submissions, invited the court to consider making a reference, and we have set out the questions for your note-keeping purposes at SMS 157 at paragraph 6, and with reference to the Sala point in the same submissions, SSMS 173. And the question with reference to jurisdiction also embraces the points made by my learned friend Mr. O'Neill with reference to Article 19 of the TU and Article 47 of the Charter of Fundamental Rights.
Mr. de Mello, would you be kind enough to try and locate those two? You've got your proposed questions for reference in two different places, well, one in one place and one in another. Could you just give me the references again?
Yes.
By reference to the title of the bundle, not by reference to the number.
By reference to I call this the supplementary bundle for today's hearing, the blue one, and that is SSMS.
SSMS.
157, paragraph 6.
SSMS 157, paragraph 6.
And with reference to the jurisdictional point, SSMS 173, paragraph 40. With reference to the jurisdiction point, you may take a view that Sarah is a child under Article 2.2, so there's no question of jurisdiction arising for consideration. But then on the other hand, if there is a doubt as to whether Sarah straddles into the territory of Article 3.2, then we would urge you to consider making a reference on the question of jurisdiction, because the case of Bangor does not concern a child and does not concern an entry clearance application. And it may well be that the Court of Justice would be assisted with the position of a child, which raises complex issues, as we have seen in a case on our facts by reference to the documents. And the court may take the view that if an order for expedition with particular reference to the jurisdiction point is taken, the Court of Justice may accommodate.
Mr. de Mello, of course, the upper tribunal in this case held that the Secretary of State had not given your client's claim sufficient consideration under Article 3.2, and it quashed her decision so that it had to be made again. Of course, the Court of Appeal set that aside. But if, hypothetically, the Court of Appeal was wrong to set that aside, I should have thought from your point of view there might be an awful lot to be said for the restoration of the upper tribunal's decision, which is that the Secretary of State should make your Article 3.2 claim again on the proper basis, with perhaps further guidance from this court as to what on earth Article 3.2 means, and whether Regulation 6 has gone beyond it.
My Lord, we have to accept that, and particularly if the view of this court is that the MK decision is soundly based, there is a right of appeal, that is with reference to Article 3.2 and Regulation 8. And in those circumstances, I can well see that that is the course that the court may follow. But if there is doubt as to whether her case properly explored falls under Article 2 or Article 3.2, it is a matter for this court to decide, because what the upper tribunal did is to say that, look, you simply don't get anywhere near Article 2. Now, if they are wrong on that, and you, meaning the court, takes the view that we can wear an Article 2.2 cap, and
well, of course, then one would have perhaps to go round, from your point of view, the lengthier route of a reference. Yeah. But in terms of wanting a decision for your client, might be an awful lot to be said for the upper tribunal's disposal.
Well, we tried persuading the first-tier tribunal on the first occasion to save money and make a reference, and to save time, because the child is concerned. But here we are today, and
yeah, well,
I've completed my submissions.
Thank you.
Thank you very much.
But didn't the upper tribunal actually allow your appeal substantively?
Yes.
So
they did so.
Actually grant you what you...
They said that we were a relative, but we might want to consider getting some kind of approval from one of the departments we pick up their decision.
Can we just see what they
Yeah.
said?
The upper,
Starts at 13, doesn't it? It starts at 149, and the meat of it is at 152 and 153. At the very end of paragraph 16, the tribunal says we're not satisfied. Adequate consideration was given to whether she is an extended family member. We'll remake the decision to that extent.
yes,
And then at 22, they say the respondent may wish to consider. In other words, correct me if I'm wrong, I had understood this to be a setting aside of the refusal
that's right,
so that the decision could be remade.
yes.
On the basis that she is an extended family member.
That is right. And, but of course, if you take the view, having granted us permission, that Sarah might be an Article 2 candidate, that's one of the permutations that this case throws up. Mr. Moomin has kindly provided us copies of, or Mr. O'Neill has kindly provided us copies of the case of Samba Diop, which I've referred to. Is that the Brahim case? Yes, that's the Brahim case. Yeah. And I apologize, I'm handing it over to you in loose leaf. It is an important case which supports us. Thank you very much. Those are our submissions.
My Lords, may I've obviously got no right to say anything at all now, but if I may very briefly give my lady the judgment that I mentioned earlier when you rightly took me to task for not having any law to support the submission I was making to you. This is the most recent case we could find dealing with the legal test for adoption of common law.
Well, thank you. Thank you.
And if you look at para 66, you will see in particular how they approach the slightly different approach to adoption taken in Paul, which is the country in issue in that case.
Talked about written submissions on Sala. Does anybody want to make them?
My lady, I also want to say something because Mr. O'Neill made submissions on Article 2.2, which I hadn't received in writing. There were new submissions, and if I may just very briefly make one point about them. He submitted that adoption, within the meaning of Article 2.2, implicit in Article 2.2, is an autonomous concept of EU law. And of course, that means that if he's right in respect of intra-community, he meant Article 2.2 should be given an autonomous interpretation. Yeah. But if adoption is to be taken into account, that must also, I understood to be saying, be given an autonomous interpretation. If I'm wrong about that, then I shan't say anything more about it. But he did make points about the 2016 regulations. Of course, those are not before you, my lords. And obviously, you have that point well in mind.
We know.
Finally, my Lord Wilson mentioned the particular provision of the regulations and queried its lawfulness. I'm not saying anything more about it except to say that its lawfulness has been considered and has been upheld in a judgment in your bundle, but by the Court of Appeal. It's Authorities Bundle 2, tab 20, KG Sri Lanka, MS page 969, para 64 and 65 in particular. Thank you.
Can I say in relation to that last point? Sri Lanka was a case decided some years ago, and if it's still being relied upon, I think we need to say something about it. The decision in that case was, as I recall, in effect reversed by a later Court of Justice decision, but I would have to find that for you. The case Sri Lanka, it's a case in the private here, and the interpretation for which I contended was rejected by the Court of Appeal, but later accepted by others some years later. But we put that to one side. And I also say that Lord Wilson's concern about Regulation 8 is probably because that's the original version of the 2006 regulations we've got in the fund. It doesn't matter, but Regulation 8 was subsequently slightly amended.
Oh, well. No, but we've got to quote it.
Well, Mr. Bilal, I can provide you with the up-to-date version.
Well, the one that applied when the decision in question was made, which I think is the one we want.
We have copies of that, the full version of regulations, which were enforced at the time the decision was made, which we can give the court and the
So
party.
is the one at 130 not the right one?
Well, obviously not in relation to, it mustn't be in relation to that part of Regulation 8, if that's what.
If you've got the right regulations there, I think we'd better have them.
We've been looking at the original version, but for the purposes of this appeal, we understood it didn't matter.
Didn't make any difference.
Oh, right, okay.
Yeah, but nevertheless, it would,
Always good to have
if
the
we
law.
ever get round to writing a judgment in this case, which is getting further and further into the distant future, we would want to quote the version of the regulations that was actually being applied by
Yes.
the decision maker,
Of course.
whose decision was under appeal or not, as the case may be.
We will hand that up to you now.
Please do, yes.
September 2012, this is the version. Thank you.
Well, sorry, there's one reference that I wanted to give you, if I may. In the case of Peruge,
Yeah.
second supplementary authorities from SSD 110. Paragraph 48, the father is placed in a car with adoption.
Well, I hope we've more or less got everything that we need. However, I did raise the question as to whether anybody wished to put in any submissions about, do we call it MK or do we give it its proper name? Is there an anonymity order?
No. We don't wish to, both Mr. Kennelly and Mr. Lask and I were involved in the case.
Yes.
At the present moment, I don't think we wish to make any further written submissions.
Well, I
I'm not
wouldn't
sure.
expect that you would, but I just wondered whether Mr. Kennelly would.
I don't think I need to. I think I've said all I can about that.
I've dealt with
Of course, thank
You
you.
have dealt
Of course,
with it,
but on a very, very final point, if you are minded to make a reference, the Secretary would be grateful for input, if that's possible.
Well, into the questions
The
asked.
questions, indeed.
Well, we would normally run the question. We normally do draft the questions ourselves because we find the parties draft the questions that they want the answers to, whereas we draft the questions that we want the answers to, and they're not always identical. But we would, of course, always ask for comment from the parties, were we to make a reference.
Milady, on the point of supplementary submissions, I mean, I don't want to add to the paper trail on this, but your ladyship did ask about appeal rights in other countries. We could look into that.
If you were to have any information and if you could potentially agree it with the others and let us have it, that might be of some assistance to us.
We'll see what we can do, Milady. I won't promise anything on that.
You're a small organisation. I don't want to suggest that you should do things when you could be better employed.
We will certainly look into it, and if there's something useful which will assist the court, we'll make sure that gets to it.
Thank you very much indeed. And thank you to everybody. I'm sorry that this case has developed in this rather messy way, but we have, I think, got all the information and arguments that we require to go away and try and work out what we think. I was going to say the answer might be, but actually we may not know the answer. We haven't decided yet whether we do know the answer. So we will go away and think about it and let you know as soon as possible. The court is now adjourned.